everyone, welcome back. So in this video we are going to go over one of my all-time favorite Supreme Court cases, Marbury v. Madison of 1803. So let's get started. So here are the facts of the case. So Thomas Jefferson defeated John Adams in the 1800 presidential election. Before Jefferson took office in March 4th of 1801, Adams and Congress passed the Judiciary Act of 1801, which created new courts, added judges, and gave the president more control over appointment of judges. The act was an attempt by Adams and his party to frustrate Jefferson, as he used the act to appoint 16 new circuit judges and 42 new justices of the peace. The appointees were appointed by the Senate, but they were not valid until commissions were delivered by Secretary of State James Madison. William Marbury had been appointed Justice of the Peace in the District of Columbia, but his commission was not delivered. Marbury petitioned the Supreme Court to compel the new Secretary of State, James Madison, to deliver the documents. Marbury, joined by 3 other similarly situated appointees, petitioned the writ of mandamus, compelling the delivery of the commissions. So what were the legal issues brought before the Supreme Court? Number 1, has the applicant a right to the commission he demands? 2, if he has a right and that right has been violated, do the laws of this country afford him a remedy? And number 3, if they do afford him a remedy, is it a mandamus issuing from this court? Well, the Supreme Court answered and ruled that Madison's refusal to deliver the commission was illegal, but did not order Madison to hand over Marbury's commission via writ of mandamus. Instead, the court held that the provision of the Judiciary Act of 1789, Section 13, enabling Marbury to bring his claim to the Supreme Court was itself unconstitutional, since it perpetrated to extend the court's original jurisdiction beyond that which Article 3, Section 2 established. Furthermore, Justice Marshall expanded the writ of mandamus was the proper way to seek a remedy, but concluded that the court could not issue it. Marshall reasoned that the Judiciary Act of 1789 conflicted with the Constitution. Congress did not have power to modify the Constitution through regular legislation because the Supremacy Clause places the Constitution before the laws. Marshall established a principle of judicial review, which is the power to declare a law unconstitutional. And just to show you what the Judiciary Act of 1789, Section 13 says. And it says that the Supreme Court shall have exclusive jurisdiction of all controversies of civil nature where a state is a party, except between a state and its citizens, and except also between a state and citizens of other states and aliens, in which latter case it shall have original but not exclusive jurisdiction, and shall have exclusively all such jurisdiction of suits or proceedings against ambassadors and other public ministers or their domestics or domestic servants as a court of law can have, or exercise consistently with the law of nations, and original but not exclusive jurisdiction of all suits brought by ambassadors or other public ministers, or in which a consul or vice consul shall be a party, and the trial of issues in fact in the Supreme Court, and all actions at law against citizens of the United States shall be by jury. The Supreme Court shall also have appellate jurisdiction from the circuit courts and courts of several states, and the states herein after specially provided for, and shall have power to issue writs of prohibition to the district courts when proceeding as courts of and maritime jurisdiction and writs of mandamus in cases warranted by the principles and usages of law to any courts appointed or persons holding office under the authority of the United States. And we will discuss Federalist Paper 78 in a different video that pretty much highlights this section 13 that was written through the Federalist Papers. And furthermore, Justice Marshall interpreted this section of Article 2 in the Constitution as setting forth the exhaustive list of the categories of possible Supreme Court original jurisdiction. Now, you can think of this as the enumerated powers of the Supreme Court. So, you know how Congress has the enumerated powers, which is Article 1, Section 8. Well, you can think of this as the Supreme Court's version of their enumerated powers. So, just a little overview. What is judicial review? Well, judicial review is the power of a court to declare acts of other branches of government or of a subordinate government to be unconstitutional and thus invalid. So what we have playing here is separation of powers and checks and balances in regards to judicial review. So what is the purpose of judicial review? Number one is deciding lawsuits, looking to the governing law to consider the Constitution as one relevant source of law, and in cases of conflicting legal documents to give priority to the Constitution and to refuse enforcement of any contravening legal norm. So basically what they wanted to do is, with judicial review, they wanted to make the Constitution, as it should always be, the supreme law of the land. So any other law is almost inferior in comparison to the Constitution of the United States. And then number two, reads the Constitution as endowing the court with the power to police and other branches, acting as the central guardian of constitutional principles and the special enforcer of constitutional norms. So they wanted to make sure that the Constitution is the primary source of law, and how we should interpret the law based on the cases that have been brought to the Supreme Court. And number two, now that we understand and having the interpretation of the Constitution, that it should be enforced based on what is within the confines and powers vested in the Constitution. So why is Marbury v. Madison so important? Well, according to Fallon, he states that it's important to understand Marbury is to understand the practice of constitutional law, or at least the judicial role, and to understand our constitutional practice to understand Marbury. The two are too much interconnected in the constitutional mind for perception of one not to color or indeed sometimes determine an understanding of the other. And this concludes our overview of Marbury v. Madison. So I highly recommend that you watch the video for Federalist Paper 78. And I will also kind of go over the Judiciary Act of 1789 so you can get an understanding of what Justice Marshall and the parties that were involved in this particular Supreme Court case, and how it has evolved into what we now know as Article 3 of the Constitution. I hope you enjoyed this video, and if you did, if you can like it and then subscribe, that'd be awesome, and have a great one.